also don't want to miss anything, but I do want to tell you guys a little bit, for those of you who are sitting here. Yes, yes, Froggy, I will. He went back in. It's in exile while I'm here working. So there's one thing I want to say about, in case you guys didn't see my video, that's really interesting, I think, about this case, is that everything I read about it made no sense. The case sounded ridiculous, like just objectively ridiculous. It was like Chevron is being sued for something that another company did during World War II. I mean, it was like, that feels, And so those kind of cases don't usually make it to the Supreme Court. When they sound that silly, it's like, So what I ended up doing, I had to look pretty far, and the place that I found more information was also really suspect. It was this long speech that one of the plaintiff's attorneys gave to like a group of lawyers in Baton Rouge. So also very suspect. But it did seem make a little bit more sense. So I kind of took some of that information and filled it in a little bit, which is that when this law was passed back in 1979, it had this grandfather clause in it that said all the bad stuff you did before today, you don't have to worry about if you start complying and you kind of come into this with us, help us kind of fix things moving forward. And that made a little more sense than just they were getting sued for something they did in 1940. Like, what? And so according to him, the reason they were getting sued for something in 1940 is that they refused to start following the law in 1979. I don't know why, guys. Oh, there we go. Okay. Hold on. It just popped in, but I don't think you can hear it yet.
At Watson. This was close supervision of what effectively amounted to a joint venture during World War II to get as much oil out of the ground, transported to the refineries that the government was helping to finance to expand, all in an effort to get petroleum products, and in particular avgas, onto the war front. So I think we could have won under that theory even pre-2011. But I do think the statute.
But you do admit that this is quite a dramatic change to the removal statute.
I would say it's a substantial expansion of the statute, but of course it's a substantial expansion that I think follows directly from the words that Congress added to the statute. And that's why I think it's really relevant that the plain meaning, the dictionary definitions of related to, always had a broad meaning, and of course this court, in cases like Morales, had said this is a very broad term, and Congress added it anyways. And so I think we should sort of take Congress at its word in the text of the statute.
But Mr. Clement, in the text of the statute, Congress also says that adding those words was a conforming amendment. And we have case law that indicates that conforming amendments don't make substantial changes. So I'm a little worried about the suggestion that this is a substantial change in light of Congress's statutory statement that this is a conforming amendment.
So, Justice Jackson, I would say you have cases that go both ways on this. You certainly have the case that the Fifth Circuit en banc relied on in rejecting this argument is Burgess against the United States, which stands for the proposition that even a conforming amendment is a real amendment and you give the words their effect. And in my reading of the cases that go the other way, they don't really deny that words that pass through bicameralism presentment have to be given their effect. In cases, sometimes you go through the analysis, effectively determine that the words don't have a dramatic effect, and then note at the end of the analysis that it was a conforming amendment.
But we do have a amici here, an amicus brief, that talks about another option that really does make sense of the conforming amendment analysis. In other words, this amicus, and I'm referring to the Governor John Bell Edwards brief, indicates that in the House report and in the legislative history, Congress explained that what it was trying to do when it added or relating to was expand the types of actions that could be brought. In other words, there had previously been concern that pre-discovery suits were not able to be removed. Congress explicitly changed the statute to include them, and then put or relating to, says the amicus, and the House report, put or relating to as a conforming amendment to that change. So what's your response to that theory, which doesn't require us to view or relating to in its broadest sense?
So two things, Your Honor. One thing would be a textual response. One would be a response based on the House report. So first, the textual response is there's no way, given what Congress did to the text of the statute, to limit it to the pre-suit discovery actions that were conceitedly the immediate impetus for Congress getting concerned about this issue. Congress could have passed a statute that said something like for or in pre-suit actions relating to, comma, and then it would have had this limiting effect where related to only modified those pre-suit actions that were added to the definition of civil action and criminal proceeding as part of the rest of the statutory amendments. So there's just no way, given the words that they added in the various parts, to sort of limit it in the way that the amici would sort of wish. But the second thing is, for those that look at House reports, if you actually look at the House report, it has a section-by-section analysis. And there is a specific explanation of what the House thought it was doing in 2B of the statute, which is the specific provision, call it a conforming amendment, but the specific provision that added the related to language. And Congress said that it was rewriting the statute to essentially expand the universe of suits that could be removed to acts that could be removed by federal officers to federal court. So
I'm sorry, finish.
I was just going to say, so in the one place in the section by section where that House report says specifically what they're trying to do, they say we're trying to broaden the universe of acts, not actions, acts that federal officers can remove to federal court. I'm sorry.
How far upstream do you carry relating to? Let's say you have a vertically integrated company, you know, a lot of inputs, changes along the way, and at the end of it, they're selling a product to the government. Does relating to go to the step that's, 10 steps above that, where they're buying the materials, they're shaping the material, all this other stuff?
I would say probably not, and I think any time you're dealing with a word like related to, there's going to be some degree of attenuation at some point where you're going to say, fun's fun, but don't die laughing. We're going to cut it off before that point. Now, I would think here there are a couple of factors that make this a relatively straightforward case. First of all, you don't have to go that far upstream. We are talking about the absolute indispensable component, which is this particular grades of crude. The other thing you have here that I think it makes it a relatively straightforward case is that you have the contract itself drawing the connection between avgas and crude. I mean, literally what the government agrees to pay for the refined avgas that it's purchasing is based on the price of crude in the East Texas fields. So the connection is very direct there. The last thing I'll say, and this is I guess the closest to something that would be like a test or a formulation that might give guidance. But I think if you ask the question, would enjoining the activity that the petitioners engaged in have a direct negative effect on the government? I mean, the answer here is clear. If you would enjoin the production activities during World War II, that would directly affect the government's ability to get refined avgas, to fight the war effort. If you go 10 steps upstream to an ingredient that one company adds and nobody else adds, I think if you ask the question, would this interfere with the federal government's functioning, the answer would be no. But here it's clearly yes.
I'm not sure that's satisfactory to me. The way you're defining this, but for now, something could fall apart. So how about an employer's strike or an employment dispute of a critical engineer of some sort?
So I guess what I would say about that is it might depend. I mean, here, for example—
Depend on what? That's the problem.
Well, I think it would depend on how—
If we define it as capaciously as you do, I'm not sure what the stopping point would be or how we would limit the application of this case.
Well, I guess I'd ask you to think about it this way. I mean, there are provisions in this contract that go to working conditions. Now here, the contract went out of its way to say that the FLSA should apply here. But if the contract said something to the contrary and a state tried to apply its minimum wage law to the refinery itself, then I think that would be a situation where you would probably satisfy the statute and you could remove.
So, but that, you seem to be arguing that the only defense is a federal defense, which is part of the test, right?
You certainly need a federal defense, and as
Right.
Judge Oldham made clear below, I think that's something that does a lot of the limiting work on this statute. And I do think it's relevant to keep in mind here that, obviously this court is concerned about these broad terms and coming up with limits, but the stakes here are a little bit lower in two respects. One, in the ERISA context, for example, or the Airline Deregulation Act context, the relating to is the whole game. I mean, it's going to determine whether state law is displaced. Here, it's just one of 3 or 4 factors, depending on how you count them. And then the second thing is, the net result of this is not that your state law claim is displaced. It's just that you would have to bring your state law claim in a different forum.
I didn't see your brief taking on the government's position that strongly, but you did so here in your opening statement. And you answered Justice Thomas by saying that the government's position would expand our case law in saying that that regulation alone could give you the nexus. So how would you limit the government's position, that it's not regulation alone, it's regulation plus what?
Well, I guess I would say you could come at it 2 ways. You could come at it and say it's regulation plus close supervision and control as a practical matter, and I think you had this here.
But that's true of most regulation, environmental regulation, for example. So I don't think that standing alone is enough.
Well, so let me give you my alternative theory, which is maybe not to think about it as regulation plus, but regulation to what end? I mean, in Watson, you have the classic kind of more typical government regulation where they're regulating, but they're regulating the provision of a product to a third party. The government's not buying light cigarettes. The government probably, all things being equal, would probably prefer there are less light cigarettes in the world than more. So it's kind of classic, the government as government regulating. These regulations, I think, are better understood as the government as procurer regulating in service of maximizing its procurement objectives. Part of the reason that they're in there regulating the spacing of the drill isn't because they have like some newfound federal interest in drill spacing. It's that they're trying to make sure that they can get material out of the ground quickly, that they can do it in a way that preserves steel, which is scarce during the wartime. And so really all of these various regulations, including the regulation of production, is done in service of procurement. And that's just a very different situation from what this court had in Watson, but it's also a very different situation from the mine run of regulation in all these cases. I mean, there's another amicus brief supporting my friends that goes through all of these federal cases involving poultry, involving nursing homes during the pandemic, and it's an interesting sort of litany of cases. But the federal courts in all of those cases were able to say, no, those stay in state court. And I think if you recognize that the kind of regulation here is distinct in the World War II context, I think that would be one way to reverse the decision below, but still not open up any floodgates.
Mr. Clement, let's imagine that I agree with you about the definition, about the causal connection here, and I think it's broad.
It's not delayed.
I'm trying to decide what would be left on remand if I took that position, whether we should just remand and let the Fifth Circuit figure it out and apply the law to the facts, or whether we should do that ourselves and actually hold that the suit is removable. One thing I'm worried about is the colorable federal defense. Fifth Circuit didn't pass on that below, and you say that respondents don't dispute it, but the Fifth Circuit hasn't decided. Judge Oldham talked about it in his dissent. That's one thing. The other thing is we've never addressed whether the federal officer has to be a federal officer now or at the time the conduct occurred. And in the Meadows case, which was pretty recent, Chief Judge Pryor said, well, it has to be at the time currently, which would not apply to your clients. So if you could address those two.
Oh.
Well, there's a lot there. I mean, first, and let me make sure I don't forget either piece. So on the first piece, I mean, I think it's critical that this court, not just say related to is the right test, but should apply it because, you want to provide some guidance to the lower courts. So I think at least you want to at least go so far as to saying this is a clear case that satisfies the test. If you want to leave the colorable federal defense issue for the Fifth Circuit on remand, I'd prefer that you go ahead and just say it's not really in dispute, but in fairness, there hasn't been a lot of briefing on that, and in fairness, I'm not worried about that. I mean, we raised a number of colorable federal defenses, and I think at a minimum, the preemption defense based on all these wartime regulations is an incredibly strong defense, and there's probably an immunity defense. So, you could do that. So on your second question, well, what can I say? I mean, Chief Judge Pryor got that badly, badly wrong. I asked on behalf of Mr. Meadows for this court to take a look at it and fix it. This court wasn't interested. But, the arguments are overwhelmingly strong that the 11th Circuit decision is wrong. But even the 11th Circuit, my understanding is, has not applied that in the government contractor case. Because, there's a lot wrong with that approach, but one of the things is it's really hard to apply in the government contractor case, because what are you saying? Like, the contract officer that gave us the contract in World War II still needs to be alive or still needs to be on the job? I mean, that doesn't make any sense.
Well, I don't know whether it makes sense or not, because as you say, we didn't take up that question before. I just don't want to implicitly resolve it here because it's a live one.
It's not a live one on the Fifth Circuit on remand. If you want to drop a footnote and say you're not deciding that case or that issue in the opinion, that would be an appropriate approach, I think.
Thank you, counsel. Justice Thomas? Justice Sotomayor? Justice Kagan?
Mr. Clement, you spoke in your opening about the apparent anomaly between
might be a
putting
faster
the
case than I
vertically
realized.
integrated oil companies in
Or
federal
they're gonna
court
come down real hard
and
on Louisiana,
having
we'll see.
the oil-producing companies that didn't have refining capacity in state court. And you said we oughtn't to worry about that. But putting aside for now the Solicitor General's alternative theory, which would treat them alike, I mean, why isn't that just a bizarre outcome? When you consider that this entire suit is about the thing that both sets of those companies have in common, not about the thing that separates them.
So, again, I'll grant you that there's like a surface anomaly, if you will, which is why my clients in the first instance are, the SG position is our position, our principal position in the Fifth Circuit until it's rejected in the Plaquemines 2 case. But what the Plaquemines 2 case says is, our problem is acting under, not really related to. And so, and even in the Plaquemines 2 opinion, it's like 4 pages long. It doesn't say much, but it does say maybe the refining companies are differently situated. And so, so I think the anomaly goes away if you think about this as principally acting under. It makes a big difference unless you accept my sort of modification based on the unique nature of these regulations. If you think the key problem is acting under, well, then it makes sense that the people who are in direct government contractual privity with the federal government get to remove, and those that are not don't get to remove.
And when acting under, are you saying that every federal contractor is acting under?
Robin,
So
you never
what
know.
I would probably say is, like, in some theoretical way, if you're a government contractor, you could come in and say, I'm a government contractor, so check that acting under box. But it doesn't do you any good unless what you did under the government contract is related to the thing you're being sued for. So if Chevron is, got a refining contract and they get sued for their geothermal operations, or they get sued for operating a corporation-owned filling station, like, related to is going to be absolutely impossible. And so you check one box, but you wouldn't get anywhere. I mean,
So
essentially.
there are 2 parts to this statute, guys. There's one part where it says you acting under a government contractor, and the other part it says for or related to. So,
And they still have to show a colorable federal.
And then unrelated to, which is pretty
and if you're doing those things, you can remove your case to federal court.
work does in terms of limiting this. But, to take a hypothetical where it's not wartime, and there's plenty of crude to go
Morning,
around,
Horizon.
and the government doesn't have a particular interest in
Hey, Crispus.
what happens at the production level as opposed to what happens at the refining level. But it's still, of course, true that the crude oil is the single component of the aviation gas. Is that enough?
Sure. I think that is definitely enough.
So all the rest is atmospherics. The fact that the government was super concerned about this and, was really looking at the production activities too in order to ensure that the refiners got the crude that they needed, even if that wasn't the case, just the fact that the crude was the component product is enough.
It would be enough for the related to box. It's a lot more than atmospherics. It's part and parcel of why I don't fear the possibility of being remanded for the colorable federal defense prong here. And if it were just ordinary, non-wartime, kind of generic stuff, I'm not sure what the colorable federal defense would be. But for purposes of the related to, I honestly think if you take the wartime context out of this and the government contracts with Chevron refining company, it's probably guessing that almost all of the crude is going to be produced by Chevron in the field because they vertically integrated for a reason. It's efficient for them to operate kind of as an internal corporate entity. So in some respects, the wartime context had a little bit of the anomaly that we didn't refine as much of our own crude as we otherwise would have. But it also provides all this other direction and control that I think make the colorable federal defense an easy piece. The other thing it does, which is more than atmospherics, is I think it provides part of the answer to why contractual direction can't be the test. Because part of the
Thank you. I'm sorry, the OB cam isn't hooked up, A, because he's sitting over there, and B, because it wasn't working.
Petroleum Administration for War.
OB, come here. Come say hi.
Justice Gorsuch.
What do you want?
Justice Kavanaugh.
There seems to be a concern about the fairness of
Robin.
the state court system that underlies your position in this case. What is that concern?
So the concern is, in a nutshell, I'm not going to try to improve on Daniel Webster, right? Daniel Webster, talking about this in the context of 1812, said there's real value in having your case litigated in a forum that respects the federal authority. And so for, really since almost the framing of the country, there's been this problem, this issue, this concern with issues that are nationally important but locally unpopular. So
that was
War
a
of
key line.
1812, not a lot of big fans of that in New England. Taxes after the Civil War or certain Civil War Reconstruction things, not a lot of fans in the South. Those are the times when it's most important to be in federal court. And as we say in the briefs, I actually think that, you can see this as a threat to federalism, but in some ways,
That line might actually be from that article I showed you guys the other day from 2003.
their chance to prove their case in court. It just has to be proven in a federal court. If they can prove their case in federal court, then everybody's going to accept the outcome, and they're not going to view it as something that's a product of local prejudice. The last thing I'll say is there are some real procedural advantages to being in federal court in terms of the ability to get interlocutory appeals, the ability to get this court to review a cert petition when it's interlocutory. So as a practical matter, it's not just like a difference in the jury pool, though that might make a little difference in a case, or it make more difference than usual in a case like this, where you still are going to have a regional jury pool, but it's not going to be drawn exclusively from people that are going to get, effectively a direct benefit if the parish collects a massive windfall.
Do you have specific concerns in this case about the state court system, or is it more the general concerns, historical concerns, and the procedural points that you're just mentioned?
Well, it's both. I'd be lying if I didn't say that the verdict in the one case that went to trial here, which was, roughly $750 million for just one parish, since the Fifth Circuit, the one time they took a look at one of these cases on a removal in a diversity context, basically said that, the state has a fatal problem with its grandfather clause argument. So I'm looking at this case in practice. I'm seeing what happened in federal court, which is we won going away. I'm looking at what happened in state court and a $744 million judgment, and I'm thinking, facial and as applied.
Right. And then
For some
you
reason, they
mentioned
didn't
earlier,
like that judgment.
and I don't know if you meant this to be a test, so I want to clarify whether you want this is something you're suggesting should be in the opinion. Would enjoining the activity have a direct negative effect on the government? Was that something that you were suggesting as a test, or just a comment you were making about the application of this case, because the word direct could, of course, assume large significance going forward.
Right. I'd live with that as a guidepost. If you were going to make it into a test, I'd take the word direct out. But, you know, I mean, this court has approached this exact statutory language in sort of different ways. In Morales, the court basically said, yeah, it's a broad term, and this is a relatively straightforward case, and we'll leave the rest for another day. So that's one option. In Watson, this court, with the acting under, sort of did the opposite, where it said, all right, this is a broad term, we're supposed to liberally construe it, but we can look to the broader purposes of the statute, and the broader purposes of the statute, it's the same statute, is to provide a federal forum in circumstances where you would interfere with the federal government's operations. So I can sort of live with that approach too. There's kind of an intermediate where you say, like, there's 3 or 4 factors that make this an easy case, and those are relevant, but we can wait for the next case when only 3 of the 4 factors are present.
Thank you.
Justice Barrett?
A couple of factual questions. And thinking about how settled the factual record is here for purposes of applying a test, it seemed like there was, I understand all the reasons why PAW is a federal agency from your point of view. I understand all of the evidence from that. But do you understand respondents to contest that point at all? Because it seems in some places like they cast doubt on it. Is that settled?
I mean, I think it's settled beyond any reasonable debate, but I suppose if there really were a debate on that, this is a context where if you think there's a factual dispute, you essentially defer to the plausible allegations in the removal petition. And, I think based on that, we're more than plausible. I mean, we have the official history that supports, I think, really what we're saying. Now, like, they point out that, well, the state still had some residual role in regulating production. I don't think they're wrong about the fact that the state still had some residual role, but it's black and white in terms of the federal government's role in the war versus outside of the war. So,
okay.
But in all events, if you thought there was a factual dispute, you still end up deferring to the plausible allegations in the removal petition, and any factual issues get sorted out in federal court, not in state court.
But didn't they already settle
Okay,
it?
second question is, Louisiana says that you grossly mischaracterize whether the state is trying to hold you liable for the World War II activities. Mr. Aguinaldo says, no, this is just about the defense. The only thing that's relevant is they're showing that the activities were lawfully commenced before the Louisiana statute was enacted. I've read the expert report, and I can see why. Right. Is it the expert report that's leading you to say that, yes, we're actually being held, they're trying to hold us liable for that, as opposed to having it be relevant solely for the defense?
So, I think as a practical matter, it was the expert report that sort of started the whole re-removal effort, and I think even the Fifth Circuit, when it considered that, said, yeah, the World War II is directly at issue here. There were hints of that even in the original complaint, because if you look at the complaint, they're asking, one of the forms of relief is to restore this to its original condition. And of course, there's nothing more effective in a state court sort of jury presentation than a before and after presentation. And the before and after photos they want to show are the bayou before the war and now in sort of 2026, whatever.
So this is one of the things I came across, guys, that was confusing, is that the law that was written in 1979 has this grandfather clause, and if I got it right, you could opt into it, but these guys didn't, and that's potentially why they're being held for the stuff behind it.
But again, the Rozelle expert report, I think, speaks for itself.
Thanks.
Justice Jackson?
So assuming that I think that or relating to was just a mere conforming amendment, and therefore we're still in the land of causal nexus, but for nexus. I thought your client had a pretty good argument that you satisfied that, but it seemed like you were giving it up in your conversation with Justice Thomas. So can you help me to understand maybe I'm misunderstanding what is necessary for causation, but I thought that the argument was that there was a connection, a sufficient nexus between the gas contracts and the production of crude oil, which is what is being alleged here.
So I didn't mean to give that up, and I thought I specifically said I'd give it a try. So let me give it a try.
Please.
I mean, yes, you could say that this is the unusual case where even if you have a causal nexus test of some sort, we would still satisfy it. In fact, I had a colloquy with the Fifth Circuit judge in this case, and who proposed but-for as the test, and I thought we could satisfy but-for if it's the test. I don't think it is the test, but I think we could satisfy it here because it is, it is both the reality that
They wouldn't have
substantial amount of crude from our own fields in these cases, and it is also an undeniable reality that the crude here is the absolute indispensable component. I mean, there's a straight line.
I thought all the arguments and the things that you were saying, for example, to Justice Kagan, the stuff about the wartime context and the actual product here was your answer to why this would satisfy but-for contact.
I mean, I agree. There's a great line in the PAW history that's reproduced at Joint Appendix page 5 that basically says, look, oil starts in the earth, and without crude, all of those towering wartime refineries would lay idle. So, there's no question that the crude in general is the but-for cause. Now, I think my friends are going to get up here and say, well, but the contracts would have allowed you to use different crude that you purchased on the open market.
But that would have cost more.
Crude that you produced. And that's the argument that tripped up the Fifth Circuit. But just to be as clear as I can, one way for us to win is the way that you're talking about, that it's just but-for. The other way for us to win is, and that was what I was trying to say.
You wouldn't have done this but for that.
Apart from the 2011 amendments, if you think the production activities are under federal authority because of the pervasive wartime regulation, then it's not, I don't need related to at all. Then it's for the activity.
Let me just ask you really quickly about the Fifth Circuit's opinion, because I understood them to be requiring a contractual directive with respect to crude oil production. And it seems to me that that test is even more stringent than a but-for. Am I right about that? I mean, that's what seems wrong about the Fifth Circuit's test.
You are absolutely right about that, and that's why I thought I could tell the Fifth Circuit that we could live with but-for, but we can't live with contractual direction.
Thank you.
Yeah.
Thank you, counsel.
That it? All right.
Mr. Roper?
Mr. Chief Justice, and may it please the court. That these suits are for, but the statute contains no such requirement, which would nullify Congress's addition of relating to. Regardless, petitioners were acting under a federal officer in producing crude, given the Petroleum Administration for War's unique role supervising production to further the war effort. I welcome questions.
Would your approach
For once, it
apply
wasn't
to
the other thing,
contract disputes with employees also?
Yes, in our view, if we're
figure out
talking
how I'm
about the
gonna
sort
fix
of
this.
direct thing that is going into the product, and of course, labor is a critical component of creating a federally contracted product, that is a sufficient connection. You, of course, don't need to even go that far for petitioners to win this case. But we have readily acknowledged that there are going to be hard line drawing problems here, although I agree with Mr. Clement that the federal defense requirement is going to take care of many of them. And we ultimately see that line drawing problem as inherent in Congress's choice to use this broad, capacious term relating to. And the way you have dealt with
Don't
that—
you think it's odd, though, that, as I think Justice Jackson alluded to, that this is simply a conforming amendment and it's doing so much substantive work?
No, not at all. I fully agree with Mr. Clement's answer there. I think the reason you only see this argument in an amicus brief and not in either of the red briefs is that there is just no way to get there textually. When Congress enacted the statute in 2011, this court had in over a dozen cases said that relating to is a broad, capacious term, and then Congress puts that language in a statute that this court, in 5 opinions, had said was a broad statute that was to be liberally construed. And so I just don't see how you can limit relating to just this sort of narrow pre-suit discovery issue. And we also know that Congress wasn't focused on just that problem, because if you look at the very next page of the Act, Congress amends Section 1447D, which creates a right to appeal in every federal officer removal case. And everyone agrees that that provision is not limited to pre-suit discovery actions. That was the basis for this court's BP decision a few years ago. And so I think it's clear from the text and context that Congress was addressing a broader issue here.
Well, you're right, obviously, that relating to is very broad, but it's hard to see where you stop. I mean, is it a butterfly effect? You know, the butterfly flaps its wings and it has the end result halfway around the world?
So the way this court has dealt with this problem in the preemption context, which we think is instructive here, is in one of two ways. So first, in one set of cases, like Morales, what you've said is that this is an easy case, there are going to be hard ones, and we leave those line drawing problems for another day. But of course, in the course of such an opinion, you would presumably explain why this is an easy case, namely that avgas, or that crude oil is the indispensable ingredient in avgas, and that the federal government itself recognized this link contemporaneously. And while I wouldn't want to suggest that those facts are somehow talismanic, in the ordinary course of common law adjudication, that is going to provide guidance to the lower courts in how to deal with it.
So you want us to do the same thing we did in the prior case and just say, well, there might be hard cases down the line, but we're not, I mean, how many times are we supposed to say that?
Sure. So that's option one of how to write the opinion. Option two is I agree with what Mr. Clement said, which is you say what you said in Watson and what you've done in the ERISA context, which is if you want to try to put more meat on the bones, you look to the statutory history, the context, the objectives, and here this court has a deep body of precedent going back to 1880 that is explaining the objectives of federal officer removal. Most importantly, protecting the federal government from interference with its operations. And to operationalize that, I agree with Mr. Clement, what we would want to do is just ask, if the defendant had been enjoined at the time, would that have impaired his ability, interfered with his ability to assist the federal government? And here the answer to that question is obviously yes, when we are talking about the production of the indispensable ingredient in a critical military product, and when the federal government banned many of the specific practices respondents faced.
So could you summarize that into a test of some sort? It seems to be part of your argument in your brief that the goals of the federal officer removal statute can provide a useful limit on the seemingly expansive reach of the relating to phrase, but how do you articulate that?
Yeah, so the question we would ask is, would enjoining the charged conduct at the time have impaired the defendant's ability to assist the federal government? So suppose, for example—
I mean,
That's
isn't
too
that going
broad.
to be true of any federal contractor? Presumably, a federal contractor is doing something that the federal government needs. So if you enjoin the federal contractor, you're going to be impairing the operations of the federal government. That seems as though you have a federal contractor, you meet your test.
No, I think that's going to fail in two respects. So one, you're going to have this sort of category of cases that are collateral to the contract. I mean, the oil companies here are doing all sorts of stuff besides refining avgas. And if we're talking about a lawsuit against their petroleum jelly factory or their plastics factory, that seems less likely to directly impede the avgas refining. And you're also going to have stuff that is just too far up the supply chain where you're getting so attenuated that this is the one product, the one ingredient that maybe they were using but everyone else wasn't using it.
Well, you just said directly impede, and Mr. Clement took that word out of Justice Kavanaugh's formulation.
Yes.
Notably.
I would
and
not
I
put
can
that
easily see that in different product lines, one might say, I have a contract in one product line, but over here, interference over here in another product line will impair my ability to meet my government contract in the first.
Give me a sec, guys. This dog's freaking out.
I think courts can exercise a degree of common sense and say, that is not plausible, it is too attenuated. Because remember here, this is the usual—
So you'd have us put direct into Mr. Clement's
I would not put direct in the test. I think
you
if it
wouldn't.
is direct—
I think you said direct in response to Justice Kagan, so I'm just trying to get—
Sure. If it's direct, I think it's obvious. But I think we know that it can't be direct because that's the sort of language of proximate causation.
We're back to
Everyone
the
agrees
Chief's
this is part of it.
butterfly effect problem then.
Yeah, I mean, I think in the
The
butterfly—
Big Bang is related to you being here today, counsel, right?
Of course. I think what you say in that context is I think courts are going to take these cases as they have in the ERISA context and the preemption context, and I don't think we have seen that flood of cases in the airline deregulation context. For example, I think courts have applied sense and said airline advertising is related to airline rates, but maybe if we're talking about a strike at the mechanics plant, wherever, that is going to be too attenuated. And maybe, some clever Mr. Clement can come up with some theory of why that is related, but I think courts have...
Oh, I guarantee you he would.
Yes, and I think courts have not struggled with that. At the end of the day, this court has offered these guideposts, and of course there are going to be hard cases, and I don't want to run away from that. I think that, though, that is inherent in Congress's choice in picking this language. Because remember, Congress is enacting the statute in 2011 after Justice Scalia's concurrence in Dillingham saying our ERISA preemption test is too hard to apply, after his concurrence in Egelhoff. And so Congress came in here eyes wide open, knowing that relating to is a broad term. And
but Congress also said what it was doing in the report. This is the thing that is a little troublesome for me, that to the extent that you are relying on arguments about what Congress actually intended, as opposed to just looking at the words of the statute, it seems to me we're in the territory where we look at the House report and see what Congress said about what it was doing. And in the House report, Congress described the existing causal nexus requirement, saying that federal officers, quote, must demonstrate a causal connection between the charged conduct and the asserted official authority.
There's a big question on the court, or a big split on the court between whether you just look at the text and whether you're allowed to look at what they wrote in these reports or not.
So if we are interested in
or to what extent?
Consistent with what Congress intended, I don't understand why the evidence doesn't show that Congress was not trying to change this standard.
So we see a difference between identifying statutory objectives by looking to this court's 150 years of case law, applying this statute, and looking in the specific House report.
No, but you said Congress is coming in eyes wide open relative to our case law. And what I'm saying is yes, and then they wrote what it is that they were trying to do in the report.
And to be clear, we absolutely agree that the motivating event for this act was that a congresswoman found herself stuck in state court in a subpoena case, and Congress didn't like that result and wanted to make sure that the congresswoman could have her case in federal court. But I don't think it follows that that specific problem that motivated the act is the breadth, is the sum total of what Congress did. And I'll, I think, offer the same answer as Mr. Clement, which is we know that from the text. And of course, we also know that page 6 of the House report, the section by section analysis.
Do you think they lose if I disagree with you?
So
do they not meet the causal nexus test here?
We would say that the relating to theory does not meet the pre-2011 test, but it does meet causation in a sort of broader sense.
No, I mean on these facts. Does Chevron lose if we disagree with you about the causal nexus requirement?
No, for two reasons. First, we of course have our alternative argument that the Petroleum Administration for War was supervising all of this directly, causally, et cetera. We also think that there is causation here, if you want to call it that, in a sort of looser, broader sense of the word, that relating to would clearly encompass along the lines of Justice Alito's concurrence in Ford Motor Company exploring this question in the personal jurisdiction context. Because we know that the reason that these companies were refining their own crude oil was not a matter of happenstance. It was because the federal government specifically told them to do that because, in part, this crude was uniquely suited for making avgas. And we also have causation here at a broader scale in that there's no question that these oil companies generally increase production to meet their needs, and so the only difference here comes from the happenstance of respondents having tried to slice this case up.
Thank you, counsel. Justice Thomas? Justice Sotomayor?
I don't know if you guys can hear it. There's some
Justice Kagan?
I'll give you a
lunacy
hypo,
happening
Mr.
downstairs.
Roper. Suppose there's an airline crash of some kind, and somebody brings a lawsuit.
Uncivil law, I think,
it's a
with
private
the
airline,
ICE
and somebody
and
brings a
Minneapolis
lawsuit and says
situation
there's a
is very
defective
much
part.
tied in with this.
And the airplane manufacturing company says, this part that you're talking about, it also goes into all the airplanes that we make for the federal government, which is a very substantial part of our business. So if you enjoin us from using this part, it's really going to affect the federal government. Does that mean that that suit, which is a standard state tort suit, should be removed?
And I assume there that the remedy is just for damages and not actually for an injunction against production of the part. In that case, I would say no, that is not removable, because, I mean, effectively what that remedy is asking for is the equivalent of an injunction against the use of the part in civilian planes. Of course, if they came in and said...
But if they're just asking for damages, which would effectively prevent, it's like, oh my gosh, if we're going to be subject to damages here, we've better find another part. So that would affect the way that the federal government is going to, maybe the federal government even asked for this part.
I don't think that
what happens
affects it in
then?
the relevant sense because the measure of damages in that case is presumably pegged to the use of the part in the civilian plane. Of course, if they came in and said state law permits us to get
Hold on,
a
HCC.
universal injunction against the production of this part for anyone ever, that we would have much greater concerns about because that would actually be impeding the federal government's contact. But just a normal state law damages action for purely civilian conduct, no.
What does it mean to have a colorable federal defense?
So this court's cases haven't fully explored that question. It's definitely something above frivolous. It seems to be, as we read the cases, a little bit more than that. But the basic gist of the cases as we take it is that when the defendant's story is that they were doing this because the federal government told them to do so, that should be a question that should ultimately be resolved in federal court.
I mean, one of the issues here, right, is that each of the three parts of this, you can always say, oh, well, that it'll be taken care of by the other prong of the test, but each of the three prongs is setting a really low bar, including the federal defense prong. It's not like you have to have a federal defense. It's you have to have a colorable federal defense, which is just barely above frivolous.
Yes, and I think that that is intentional. When you think about this statute against the backdrop of Congress's authority under Article 3 to put every federal defense in federal court, and so Congress has created this exception to the well-pleaded complaint rule, and it has identified this subset of cases that most directly implicate the federal government. And we don't want that to be an extraordinarily high bar because, again, as Mr. Clement said, all we are talking about here is a forum, and when the defendant has a plausible story that the federal government told them to do this, that is a story we ultimately want to be resolved by a federal judge in federal court.
This guy's like
I mean, in the context of this case,
only
I
a
don't
few years
think
out of law school, so
it
it's
casts
pretty
any
impressive.
aspersions on the good people of Plaquemines Parish to say that when we're talking about liability for conduct that the federal government directed during World War II, that is a question that should be resolved in federal court.
Justice Gorsuch?
Your argument in your brief had a lot to do with the production of crude as opposed to the refining activity. That wasn't a central feature of the petitioner's argument, and respondents contend that it was way below. Thoughts?
We definitely disagree that it's waived. If you look at page 6 of the amended removal petition, it is preserved, at least at that stage. I agree they did not continue to press it, but the reason that argument is in our brief.
You're saying it was presented to the district court, but not to the Court of Appeals.
Correct. I would say it's forfeited but not waived. And we, of course, are happy to win on relating to. That's the part of the statute that applies directly to our officers. So we are, if anything, prefer the refinery theory. But the reason that that argument is in our brief is twofold. First,
That's enough for me.
Okay,
Thank
thank
you. Appreciate it.
Justice Kavanaugh?
If we define relating to too narrowly, from your perspective, what are the effects on the federal government going
Just
forward?
above frivolous.
So Justice Kavanaugh, we think it's important to remember that this statute comes out of some of the most intense moments of state and federal conflict in our nation's history, like Reconstruction, Prohibition, and the South Carolina nullification crisis.
Impressive.
So we have deep concerns about cases that do have that risk of interfering with the federal government's operations proceeding in state court. This case is, of course, a poster child for that. A couple other buckets of cases that are of concern to us are, first, the sort of retaliation scenario that is laid out in Senator Lee's brief, where you have those assisting the federal government as contractors or in other ways with whatever is the controversial policy of the day, being targeted by hostile states or localities who know not to go after the federal conduct itself, but sort of work around the margins
ICE contractors.
to go after the federal contractor. And in that scenario, if you have a federal colorable defense and plausible allegations that the suit is relating to the federal conduct, we absolutely want that case in federal court. The other bucket that concerns us is the military contractor scenario.
There we go.
There's all of these failure to warn asbestos cases that are cited at page 28 of Mr. Clement's brief. I think the logic of Louisiana's argument here is that all of those cases go to state court because the contractors were not acting under a federal officer in giving warnings. The government only said use asbestos, and it didn't say anything about the warnings. And when we're talking about how federal contractors are implementing their federal contracts, especially in the military context, we definitely want a federal forum there as well.
And does that worry extend to incentives for military contractors going forward then?
Yes, that is also a concern as well. I mean, we think the Fifth Circuit's ruling here is really novel. This contractual directive test we don't see anywhere in the statute or this court's prior cases. And the idea that you would need a specific term in the contract addressing everything that you might be sued over, we see as deeply unworkable and also problematic.
Thank you.
Justice Barrett? Justice Jackson?
Thank you.
Thank you, counsel.
right.
Mr. Aguinaga?
There's two down.
Thank you, Mr. Chief Justice, and may it please the court. The federal officer removal statute authorizes the removal of a civil action commenced against a person acting under a federal officer. As that statutory text suggests, you have to look at the complaint that actually commenced the civil action. That complaint tells you the acts by the defendant that are charged, and then you ask, did the defendant commit those charged acts under a federal officer? That is the straightforward reading of the statute that is reflected in the Watson Court's statement that a defendant may remove to federal court only if, in committing the charged acts, he was acting under a federal officer. And that's what we think makes this an easy case. Petitioners not only abandoned below any argument that they were acting under a federal officer in committing the acts charged in our complaints, but they also told the district courts in italics that they did not need to be acting under a federal officer in committing those acts. And let me be specific about those acts that are actually charged, because we now know, having gone to trial with Chevron down in Point Lahash, that they do not dispute that they dumped billions of gallons of produced water from oil wells directly into our marsh, both before and after 1980. That's why this is such a massive deal for the state of Louisiana. And that's why I think they abandoned any theory that they acted in that misconduct way under a federal officer. All that is why I say we think this is an easy case and the court should affirm. I welcome the court's questions.
How much can you rely on Watson, which is quite different factually? It's a heavily regulated company versus, and it was pre-2011. So how much work does Watson actually do for you?
Well, Your Honor, I think Watson's extremely important for us because one thing it does is it catalogs this court's cases going all the way back to Tennessee versus Davis, where the court has said, and this culminated in Watson, the court said all of those precedents, when they're talking about acting under federal authority, they're talking about an agent of the federal government that is acting within the scope of his authority. That's the backdrop against which this court decided Watson. And so I think when you open your analysis section in Watson and you say that a defendant can only remove only if he engages in those charged acts while under a federal officer, I think that's what this court was summarizing, was that entire backdrop of precedents that led up to Watson. Now, I will say, Your Honor, I think the court's decision in Tennessee versus Davis, you look at the Willingham case, what Watson says and reflecting on all those precedents is that when we talk about an agent of the federal government acting within the scope of authority, we're asking about somebody which is basically executing federal duties, except they're doing that on behalf of a federal officer. And that's why we pointed out in the red brief this fundamental disconnect between this refinery theory, which we could not sue. We could not sue petitioners under our law on this refinery theory because we literally can't grab conduct that is 300 miles away in Port Arthur, Texas at a refinery and say that violates our coastal law. That disconnect on the one hand, whereas the charged conduct that we've outlined in the complaint is literally in the marsh in Plaquemines Parish. This court has never seen, and petitioners have not identified for you, any case where this court has basically mixed and matched the acting under conduct that satisfies prong 1 with whatever the conduct is that satisfies prong 2. Now, my friends on the other side talked a lot about preemption, federal colorable defenses. If I could hit one thing strong this morning, it's this idea that they have a federal colorable defense. Justice Barrett, you asked about whether that's a live issue. I thought to myself, we don't actually have to speculate about whether, how these defenses shake out because we've gone to trial. So if you go down to the public records there at Point Lahash in Plaquemines Parish and you look at the 18-day trial that we had with Chevron, I said, my gosh, I'm going to read that transcript back, front to back and see how did this narrative of the federal government's bidding in World War II play out and how did the preemption defense play out? And you know what? The jury heard crickets on that because none of that was raised in the Roselle trial. I think that's as dead a giveaway as any that for all the narrative you see in your briefs in the federal courts about how this is us targeting World War II conduct and everything they did was directed by federal officers, nothing like that in the actual state court proceedings. I think that's the exact same story that would play out in federal court. And, that's just the fundamental mismatch in practice. That's the reality, Justice Barrett.
Mr. Aguinaga, I have a question about whether you designated the parish's counsel to represent you in the Fifth Circuit. On pages 34 and 35 of your brief, you try to run away from that concession that counsel made before the Fifth Circuit on the acting under prong, and you say, well, Louisiana didn't appear. But didn't the counsel for the parishes represent you and appear on your behalf and concede that point?
So a couple of things there, Justice Barrett. We were out counsel table for sure with the parishes. We've been in lockstep with the parishes the whole time. And so we ceded our argument time to the parishes to represent all of respondents here in the Fifth Circuit. No doubt about that. I do have to push back on the idea that we're running away from a concession because, as you know from that part of our brief, we vehemently disagree that there was any concession. I mean, I think the whole point, if you look at our Fifth Circuit briefs in both Cameron and Plaquemines Parish, the whole point of those briefs was Watson. It's this mismatch. It's like we told the Fifth Circuit, look, they're coming to you with this idea that under the refining contracts, they were acting under a federal officer, but we haven't sued. That was the whole point, and I think that's why you saw the Fifth Circuit take that on directly, and they rejected our argument, no doubt, unanimously. But that's the basis on which we won in the district courts. That was the whole arguments that we pressed in our Fifth Circuit briefs. And if you listen to that argument audio, I mean, with all respect to my friends on the other side, I don't think that's a fair characterization of what we argued at oral argument in the Fifth Circuit.
But you did, the parish's counsel did speak on your behalf. So if I read that transcript differently, then it does bind you too.
So, Your Honor, I'm happy to take, yes, I think, that,
Yeah.
as I say, we've been, we have a joint defense agreement. We've been consistent with my friends from the parishes the whole time. And all I'm saying is that if you listen to that audio and then you look at our briefs and you look at the arguments we made in our bios here, we have been making the exact same argument the whole time, which is you could conceive of the federal, the federal refining contracts and the conduct under those contracts as acting under conduct if you had a suit that actually targeted refining activities.
Mr. Argan, I have
But-
another question. Do you understand there to be a factual dispute about whether PAW is a federal agency?
So, Your Honor, we have pressed in our briefs below, and I think my friends from the parishes pressed in their red brief here, the fact that the very textual point that if you look at the statute, it requires acting under a federal officer. And I think, there's some dicta in the court's decision in Watson that, and I'm actually quoting that first sentence in the analysis section where the court refers to acting under an agency or officer. The statute itself requires acting under an officer. They've never identified a particular officer that they were purportedly acting under instructions, from. I think a fortiori, if you were to look at the agency question, I don't think the statute actually allows them to come into federal court on the theory that they acted under a federal agency. But we have preserved that sort of threshold argument that, like, if you look at the right federal actor, there is no particular federal officer that they've identified. And then if you think of PAW is an agency, and we've not spelled that latter argument out, Justice Barrett. I mean, I think that's one thing that is interesting, but in all candor, we haven't spelled out.
I'm a little concerned about what I see as a conflation of the different prongs in your argument. And you've said a couple times that what we should be looking for is acting under conduct, or did the defendant commit those acts while acting under a federal officer? And that's not the way I understood the statute to be read. I thought acting under was one prong, and it was related to the authority that you have as this defendant, whether you're a federal officer yourself or you're not, but you are acting under the authority of the federal government. And then we have the for or relating to any act. Mr. Clement says the who, the what. I see that, and you, I think, are collapsing them. So can you help me to understand why you're not?
Sure. So if I could give you a textual response based on the statute, and then just a response based on practice from the asbestos cases. So just as a textual matter, Your Honor, I think paragraph 1 in our red brief was very delicately crafted, because I think the right way to interpret the statute is to say, it's a focus on the subject in the prefatory language in 1442A1. If you look at Pet App 182, the very first sentence, right, the subject there is a civil action. And then the rest of A1, what it's doing is telling you which civil actions may be removed. Now, my friends on the other side want to make prong 1 about who can remove and prong 2 about what suits can be removed.
But doesn't that follow from our
This
case
is
law? I guess I can't
Louisiana
figure out how
talking, not
Willingham
Chevron.
comes out the same way if you're right.
Right, Your Honor. So what I'm saying is that on our view, if you say that the rest of A1 basically asks which actions can be removed, prong one is which action, the action must be against a specific defendant. And the textual point I made in my opening is that if you take that phrase, a civil action commenced against a person acting under a federal officer, implicit in that language is a presupposition that that defendant has acted under a federal officer. Where do you go to find whether that defendant actually acted under a federal officer? The complaint is the one that actually commenced.
Are you saying that the act must be directed by the federal, the act in question has to be directed by the federal officer in order to give grounds for removal?
No,
Is
Your
that
Honor.
what you're saying?
No, Your Honor.
Okay.
And that's why I think that, this attack from the other side on that point is a bit misleading. So let me go to the asbestos cases, because we actually agree with pages 31 and 32 of Mr. Clement's.
But I mean, that is what the Fifth Circuit said here, didn't it? I mean, that was the basis for the Fifth Circuit's ruling, was that the production of the crude was not directed by the contracts. And so that's why, right? I mean, am I wrong about that?
So I think you're right, Your Honor, but I think what the Fifth Circuit was recognizing is the mismatch problem that we outlined in our red brief. They tried to solve that problem at prong 2, and our humble submission was that you should just solve that problem at prong 1. Now, if I could tell you why I agree with Mr. Clement's description of the asbestos cases and how they shake out pre and post 2011, remember the basic fact pattern in those cases is you've got a federal contract that says, contractor, you go refurbish a Navy ship and you install asbestos. So pre-2011, if there's a failure to warn claim about the asbestos being installed, the courts say, and the Lachiole panel in the Fifth Circuit, which had that same fact pattern, said, this doesn't suffice for federal officer removal because the claim is not for an act that was directed by the federal government. Now, post-2011, you've got related to, and as Mr. Clement says, once there's a failure to warn claim, it may not be that the federal government said specify these warnings or don't include warnings, but that doesn't matter. And that's why you have the outcome in Lachiole 2, the en banc decision from the Fifth Circuit that says, look, when you engaged in the act of installing asbestos, unquestionably, that is an act under a federal officer. That's prong 1. And so the only question remaining is prong 2. Is your failure to submit safety warnings or submit safety gear to your employees related to that act under a federal officer? That's why I think, the idea that our theory somehow dooms federal government contracting as we know it doesn't hold up, because we're perfectly consistent with the asbestos cases that I think are the prototypical cases where you're going to see government contractors come to court and say, we deserve to be in federal court because we, installed asbestos pursuant to the government's contract. I think that's the important piece. Justice Jackson, you asked about but-for causation. I'd like to talk about the test for my friends on the other side and trying to answer the court's limiting principle questions about how far does relating to go. Now, I'll pick up where Mr. Clement did, which was with his colloquy with Judge Engelhardt at the very end of oral argument in the Fifth Circuit, where Judge Engelhardt asked him, are you basically saying that this is a but-for causation standard? And Mr. Clement says yes, as he says today. And I was a bit taken aback by that, because they don't have a but-for causation argument in this case. Think about it. There is no argument that but for the avgas refining contracts, they would not have engaged in, for example, dumping produced water from oil wells into the marsh. One way we know that, if you look at the PAW history book, look at page 176, 189.
We would have still been doing this stuff no matter what.
Is that 70% of the nation's crude oil was actually going to civilian use, not military use, civilian use. Our expert cites that at JA 67, and the whole point is that industry would have been engaging in the exact same conduct that we charged in our complaints.
It would have been a little worse, but they still would have done it.
Contract existed. And I think, to your point, Justice Barrett, about open questions in the case, that is one of the most important things, because for all of the narrative from my friends on the other side that, this was a natural consequence of their avgas refining contracts, that is inconsistent with the historical record. And so I think, that's the answer on but-for causation, Your Honor. And so if that's the outer limit of their test, then as a factual matter, whether we win it here or we win it back on remand, we're going to win that issue, because there is no argument that but for the avgas refining contracts, they would not have engaged in, for example, the dumping of produced water into the marsh. Now, the other thing I would add to that is just the argument that, I take my friends, and we talked about the narrative in World War II. There was a line from Judge Oldham in dissent below that said it's hard to tell how they would have been able to satisfy their avgas refining contracts if they had not produced oil. And respectfully, that too is directly contrary to the record. For one thing, I mean, just look at pages 217 and 218 of the PAW history book. The problem, and this is a section called the Gulf Coast Surplus, the problem that Louisiana refineries had during the World War II era that my friends want to focus on is they had too much oil. There wasn't enough transportation to take oil throughout the rest of the country, and that overstimulation, that oversupply of oil on the Gulf Coast meant that there was a serious concern that the refineries would actually have to close for lack of storage capacity. That's in the PAW history book, and what they say is that throughout the war, the refineries actually had to operate at 70% capacity of pre-war levels just to avoid this oversupply of crude oil running them over. I take my friends, I understand they want to make this case about World War II. With all due respect, our experience in the Point Lahash trial in Plaquemines Parish and the historical record, the sites I just gave you, directly contradict that narrative. And if the court has no further questions, Mr. Chief Justice.
Can I give you an opportunity to respond to the amicus brief from General Myers and Admiral Mullen,
By the
which
way,
says,
CompuBear?
Among other things, that
My heated
the Circuit's
rivalry duck.
approach would set a dangerous precedent
Thank
that
you.
could adversely impact our national security,
It's hard to see.
discouraging private parties from
Player.
taking direction from federal officers for fear of future liability, weakens our armed forces while strengthening our enemies. Devastating implications for our national defense are not hypothetical. After September 11th, for example, our nation needed specialized protective equipment, which the military did not have. If private sector parties producing the equipment had said no, fearing future liability, that would have left our troops at great risk. So I just want to give you an opportunity to respond to that fairly strongly worded amicus brief from General Myers and Admiral Mullen.
Yes, Justice Kavanaugh. The thing I'd say to that is my friends on the other side say we're trying to take the court's precedents back to pre-2011, a 2011 standard. I think if that were true, then we would have seen evidence of all of this parade of horribles for the decades that this court's removal precedents required exactly what they say we're trying to return the court to. You don't see anything in those briefs, and like I admit, the rhetoric's strong, but where are the examples of the government contractors who said, man, before 2011, because of the federal officer removal statute, the way it's been interpreted by the Supreme Court, we're not going to engage in contracting like we'd like to. You don't see anything in the amicus briefs on that point, Your Honor. And so I think you should take the rhetoric from lawyers' pens for what it is. And, I made the point with Justice Jackson earlier that our theory of the case is perfectly consistent with all of the asbestos cases, which is the mine run removal case that the federal courts are going to see. And so, with all due respect, the rhetoric is unfounded. Mr. Chief Justice.
Thank you, Counsel. Justice Thomas?
As a practical matter, what difference does it make to be in state court as opposed to federal court?
Well, Justice Thomas, I'm not going to lie that, we have the same reasons for wanting to be in state court
They
that
want to be
anybody
out
who
of it.
sues under state law wants to be in state court. We want the actual experts interpreting state law, especially when we get to the Louisiana Supreme Court on an
And?
important statute like this, and especially with respect to a problem that is so sweeping in scope.
A local jury.
Justice Sotomayor?
If you were to lose on the acting under, do you automatically lose on the relating? If we accept the Fifth Circuit's view, then how do you win?
So the answer is no, Your Honor. I'll admit it's a harder question, but I think we still win for exactly the reason I was articulating earlier to Justice Jackson, which is if you want to take my friends on the other side as asking you to adopt a but-for test, well, look at the facts in this case and ask, but for these avgas refining contracts, would they have...
What do you do with the relating to language?
So, Your Honor, as we've said from our bio and through the red brief, we've interpreted the relating to language, with respect to this court's decision Morales, I think in lockstep with how my friends on the other side have interpreted it. In fact, that's the very language that the court below and the en banc court in Latulay, in the Fifth Circuit's decision in Latulay, adopted. We have no quarrel with all of that black letter language. I think the question is, on particular facts, how does that test shake out? And what I'm saying when I reference the but-for causation standard that I heard from my friends on the other side, ask how that shakes out. It does not shake out for them on this historical record.
Justice Kagan?
And could you respond to the Solicitor General's alternative argument, just so I'm sure I know what your view of that is?
So, Your Honor, our frontline position, we cited docket entry 87, which was their advisement to the district courts that they were going to file a cert petition in this court on that alternative theory, and that they were only preserving that theory pending this court's resolution of it. After you denied cert in Plaquemines 2, you never saw that theory again from my friends. And, we raised the problem in our bios. We said at pages 19 to 22, this is a problem for you. My friends from the parish cited at page 29. They said, Watson's a problem for you. You never saw this alternative theory in the cert reply or the opening blue brief, right? And so that's our top line response, Your Honor, is that, they made a strategic choice, heavily lawyered case on the other side of this case. They made a strategic choice to say, obviously, the Plaquemines 2 decision says what it says. We're not going to press it anymore.
Yeah, how about a substantive response?
So a substantive response, Your Honor, and I'll say we're not scared of the argument for one reason. My friend, Mr. Clement, quoted from you the heading starting the chapter on oil production in the PAW history that says oil starts in the ground. I ask you to read the conclusion. Read page 189 that says the government's treatment of production of oil in World War II was subject to a minimum of regulation. That's a direct quote. That's the federal government's own conception of what it did. And the way we know that, Your Honor, if you look at page 176, is a key part of how the federal government treated the actual production. This is far upstream, the production of crude oil. They left that to the states. The only thing they did each month was say, states, we think this is a certain capacity you could reach in terms of producing crude oil for this month. And then, and this is actual language in the PAW history, it says, we're leaving it to the state regulatory agencies to determine how to implement that if they so wish. That's minimum regulation, Your Honor. So if you're looking at Watson and you stack that up against the historical record on that alternative theory, that theory fails 100 days out of 100.
Justice Gorsuch?
On the relating to point, I didn't hear you make an argument that it's a mere conforming amendment. Thoughts?
So, Justice Gorsuch, the record is undisputed that it is a conforming amendment. If you look at the heading...
I understand that. That's not
Gorsuch
really my
only
question.
likes
I'm trying to
text,
get at,
so...
Did it do nothing? Or do those words that Congress added mean something?
Can't have
and
done
I didn't
nothing.
hear you contest that they mean
Gorsuch
something.
definitely won't like that.
In fact, the test is a very broad one. You concede in your brief.
Gorsuch will want to hear what it meant.
So they absolutely mean something, Justice Gorsuch, and I think the way I'd approach that question is to say two things. What does Section 2B in the Act do? To the big amendment in the 2011 Act was to change what is now D1 to redefine a civil action. As my friend from the government said, the whole point was to capture pre-suit discovery procedures. So that's why you see D1, what is currently D1 in the statute, this redefinition. Section 2B, conforming amendments. Conforming to what? I think what Congress was trying to do by adding the phrase relating to...
I understand that, but there's been a suggestion that the result of that
Right.
is that it doesn't change the standard, and it remains for and not for or relating to. But I don't hear you in your briefs, at least, suggest that argument. I hear you admitting that relating to is quite a broad test.
Your Honor, and we have, and I'm not going to back away from that. That is absolutely the case.
Probably
Congress
should.
said what it said. It included the words it did, and that's why
just
we
got a
think
chance.
that stories like Latulay and the asbestos cases, those two decisions from the Fifth Circuit that came out different ways, that's why they do. We're completely comfortable with that, and the only reason I bring that up is to say the mismatch issue in this case.
No, I understand the mismatch point, but you agree that those words have meaning and that they change the meaning of the statute.
Absolutely, Justice Gorsuch.
Why?
Absolutely.
Justice Kavanaugh? Justice Barrett?
Nope,
Justice
that was
Jackson?
not the right thing to say.
Thank you, counsel. Rebuttal, Mr. Clement?
Thank you, Mr. Chief Justice. Just a few points in rebuttal. First, let me start with the one and only thing I disagree with the government about, and that is we did not forfeit this argument in the Fifth Circuit. We stopped making the argument because we lost in Plaquemines 2 and then had cert denied. And I think it's really important for those of us that practice appellate law that in that posture you don't have to keep making the argument at various stages of the case. I mean, the VMI cert deny sort of says that. The NFL cert denied says that. So unless you are going to all of a sudden have appellate lawyers have to lard up their appellate briefs with arguments that are already foreclosed by appellate precedent in that circuit, I think it's very important not to find any forfeiture here. Now, I would say two other things. First of all, I think the second question presented is broad enough to capture this theory. And in all events, if anybody's opened the door wide open to a discussion of the acting under prong, it is my friends on the other side. So I think we are perfectly, the SG's theory, which is our theory from Plaquemines 2, is squarely before this court. A couple of other quick points. First, on the war. The war context of this is critical. My friend says, well, 70% of the production out of the fields went to civilian uses. Civilian uses in World War II were the home front. They were like fueling the factories that were making munitions. And if you read the Petroleum Administration for War history, it makes this point that the reason the federal government was all over this is that oil was absolutely essential to everything, including the home front. And
Either it's government or it isn't.
Debate about exactly what happened in World War II. Boy, I think first that should take place in federal court. And second, you should probably take a look at the SG's brief, including at pages 6 or 7, when they point out that there were regulations that go down to the level of the drilling angles and the production. Now, as to the statutory text, I think it's important that if you look at the statutory text that's in the U.S. Code, this isn't even a close case. Related to's in there, it's broad as can be. Now, I'd hate to have a world where all of a sudden, like, my U.S. code has to have yellow highlighting on certain words because they were put into the code by a conforming amendment. And all of a sudden, I should take those words less seriously or figure out what else Congress was trying to do in 2011 and limit the words that are there in black and white. I think that's a dangerous path to go down. But if you're going to go down the path of legislative history, the phrase that we've all on our side relied on from the House report is not some stray comment. It is the section-by-section explanation for what they're doing with rewriting the statute. That's the words of the House report, and it's to broaden the universe of acts that enable removal. So Congress actually knew what it was doing here. Last point on the test. If you're going to have a verbal formulation, please don't have the word direct in it. I actually think, though, that maybe the better path here is to say that there are 3 or 4 factors about this case, that it's the indispensable component, that the contract itself mentions the connection, that the war effort is directly interfered with if this is enjoined, and leave it at that. Thank you, Your Honor.
Thank you, counsel. The case is submitted.
All right. So, there we go, everybody. Yeah, that was a. Usually he's Clement's a little bit more on the money. So, a couple of things. Real quick, if anybody was still confused by anything at the end, what we were dealing with there was a question about whether or not. So this was all damage done in Louisiana over a really long time period, but some of the damage, or at least a chunk of the damage, was done during World War II. And so the defendants, Chevron, who were not the people who did this, but they bought the companies that did, said, well, we were basically ordered to do this by the federal government. Oh. Hold on one second, guys. Sorry. I apologize. You guys couldn't hear that, but my thing jumped over to another live court hearing in a different court. It was like, whoa. Okay. So they, let me think where I was. They said, the federal government basically told us to do this. The federal government, if an officer does something, the officer would have been able to remove this from state court, where they have to get a local jury from, that lives right in the area, and it's going to have a lot of interest in, having a huge verdict in favor, to a federal court, which is going to be in New Orleans. It's a few miles away. It's going to be city people. They're just not going to care about this as much. It's going to help them out. And if it gets appealed, it'll get appealed to the Fifth Circuit. And the Fifth Circuit hates big jury verdicts. They are not fans. So they want to move this. And they're saying, well, the government made us do this. They would have been able to move it. We should be able to as well. And this statute says that if you do something, used to say for a government officer, now it says for or related to a government officer. And there's a lot more language in there, but that's one of the main key points. So the question is, was this for or related to what the government officer told them to do? The government officer told them to ramp up the contract they had, which was to refine oil. You refine oil, you bring in crude to a factory, and you turn it into gas, air gases, avgas is what it's called. That happens in a factory. That is not what we're talking about. But they needed more crude to do that, and they could have bought crude. They could have bought more crude from any of their competitors or whatever, but that would have cost more money. So instead, they just grabbed their drills, ran into Plaquemines Parish, and just started digging like crazy and did all kinds of damage. And the question is whether that part of the decision to go start digging like crazy and kind of throwing caution to the wind, was part of the government's order to increase production. Turn the factories into overdrive. And so that's sort of the question. But there's this broader question in general about how closely the things that you do as, say, a government contractor have to be related. How close the nexus has to be between what the government told you to do and the actions you actually take. Because as you heard Chevron saying, or Paul Clement saying, you can't make gas without crude. So when they said, go make more gas, they meant go get more crude. And that's kind of implied. One way or another, it sort of is, but did that mean go dig for more crude, or did it just mean go get it? So that's sort of the question, is how closely related do these things have to be for you to be able to use this statute? And because the statute was changed in 2011, that was sort of what they were talking about, with either, are we going to look just at the way it's written? Are we going to look at the legislative history, which some of these judges really don't like doing? And so that was one of the questions going into this. Gorsuch, in particular, not a fan of that at all, and we're going to talk about that a lot with the case tomorrow, because one of the cases tomorrow is transport's case, and one of the biggest cases that is going to impact it was pro-trans rights and written by Gorsuch, which was a bit of a surprise, but it's written, the reason he wrote it is because the law that he was interpreting says in his read of the plain language that that's what he should do, and so that's what he says. He's very into reading what it says and doing what it says, and that's it. So when he starts asking the guy, like, well, how much are you reading into this, or how much are you just reading it? That's what he's implying. He doesn't like to read stuff into it. So Alito stepped back because he said he had financial interest in the company, in Chevron. So he recused himself from the case. I think that that was, Gorsuch and Barrett both are interesting me more and more over time. One of the things I noticed right at the end there, so this is going to be the question that they're going to have to wrestle with is figuring out a nexus test. And Clement, right there at the end, I think was calling for a factor test, which means they'll come up with 3 or 4 questions that a judge will have to sit down with and answer in order to figure out whether part 1 and part 2 are close enough to create that nexus. And that's what he was asking for. He said, if we're figuring out a factor test, that's what he meant was, 3 or 4 factors that a judge will consider to make that answer. One of the things that was talked about a lot, they talked about a conforming amendment. The issue there was, so there were a couple of revisions that were made in 2011, and there are different sections of it. Section D, which is not the section we're talking about, had some really substantial changes to it, and the Louisiana lawyers' read on this is that the only reason they made the change up in Section A that we care about today is because they were trying to make it line up, to make it conform to the big changes they made in Section D. They were just trying to line it up. Since they were making changes down here, they had to change a couple of words up here to make it line up. That was the question, whether it was a conforming amendment. And the problem is, as Gorsuch said right there at the end, Mr. I like, what's it say? Hey, Harambe, what's it say? He doesn't, saying that the words don't matter is not something you're going to get away with him, ever. So that was a bit probably, you could feel that wasn't going to play. And that was exactly what he was asking for. So one way or another, if they change the language, it has to mean something. And so that's kind of what he was saying. What was it? Oh, and then we talked about the but-for causation. But-for is one of the classic things you learn first semester of law school because it's a really important thing in torts, which is, this is a tort probably a tort. I don't know, it might be anyway, whatever. Tort is damage. It's money damages. When you get hurt and getting hurt costs you money, you sue somebody to get that money repaid. And one of the requirements of that is that you generally, is that you prove that you were hurt and that the hurt was caused by the person you're suing somehow. And often that will come from but-for causation. But for their actions, I would not have been hurt. Something like that. That's not exactly right, but that's somewhere scraping around the back of my head. So but-for is something, when we hear it, it's like a light switch flips. Like, I know what that means, but when they just keep saying but-for, as though it's a word on its own, it's like due process. When lawyers say due process, and they don't put it into context of a sentence, and it's like these are actually words that have meaning and are used in a sentence in real life. But the land was hurt, the environment was hurt, the people that lived there were hurt. There were the two big things that they talk about were digging canals and not filling them in. Because this is the part of Louisiana right down, they call it either the bird foot or the chicken foot, down at the end of the Mississippi River. Where we go? Where it looks like that, way past New Orleans, where it kind of sticks out. That's Plaquemines Parish. And it is just about as much water as it is land. And so it's really easy to hack up. And so they put these canals everywhere and they didn't fill them back in. So that was one thing. And then the other thing is that when you dig for oil, it's very unscientific, guys, is you pump stuff into the ground, you pump chemicals and stuff into the ground, and what comes out is oil and produced water. Produced water, super toxic. It's full of arsenic and radium and lots of bad stuff. And so what do you do with this produced water? Well, you're supposed to dig a big hole and bury it in a concrete-lined thing. And instead, sounds like they just kind of, dug a little trench and dumped it out for like decades. I think I heard one thing that either BP or Chevron, I'm not sure which, did not build an actual tank in Plaquemines Parish until 1994. So they'd just been dumping it until then. and it's super, super toxic. So all of those years of damage would have done a lot of bad stuff to, fish and everything. The water, people are drinking that water. But that's why, there are 41 or 42 cases open right now, and the first one got a $745 million judgment. So it's going to be a lot. So but-for causation, that was the last thing I wanted to say, was interesting. And again, we're going to talk about but-for causation tomorrow because Bostock, which is the case that Gorsuch wrote about Title VII gay and trans rights with getting fired. He used but-for causation when he was reading it, and I think that's going to play in. We'll talk about it tomorrow, but keep your eye open for that, because I think it's going to be, he was like, we're trying to figure out what this means. I'm going to try using a but-for causation, and I was like, oh, interesting. So we'll talk about that more. Let's see here. Wait, I missed a message. But for the reckless driving of the vehicle, complainant would not have suffered bodily injury. Yeah. And one of the things that, this was interesting. One of the things that the third lawyer said was, if they're, because the first two, one of the first two lawyers, maybe both of them, had said that they would win the case on but for. And the third lawyer said, no. But for the government telling them to ramp up production, they still were digging for oil and dumping the stuff on the ground. So they may have done more of it, but you can't say that but for the federal government telling them to do that, this damage wouldn't have been done. More of it might have been done, but no, there's not a but for causation there. So, so we'll see. I mean, the thing is that, like I said, Chevron has already lost a $745 million judgment here. The question is whether it will continue to stand. And there are implications from this case. And I'm not 100% sure that I've nailed them all down yet. I had like 15 different things I was reading at once, and I was trying to like draw lines between them. Pepe Sylvia, if anybody follows that joke. But related to the questions about what happened in Minneapolis and the officer liability questions, and Section 4, what was really kind of weirdly funny is that I'd been researching Section 1442 about that, and then I went to research this case, and all of a sudden I was like, just reading an explanation of it, and I was like, this sounds like Section 1442. What are the odds that just randomly I happen to know what U.S. code section they're talking about? And then I looked and I was like, yep, it's 1440. All right. It's a weird little world. So, all right. Tomorrow is it's trans kids in sports case. It's actually two of them. I've not entirely worked out yet exactly where the lines are between them, because sometimes they will run two cases at the same time and really let them be sort of intertwined, and it looks like they are actually going to go all the way through one case and all the way through the other case, which is a little weird from what I've seen, because they are so similar. So there must, and they are a little bit different in that one seems to be more based on a Title IX argument, and one seems to be more based on a Ninth Amendment argument. But this one is going to be fascinating, you guys. I wish trying to figure this out took me so much work, because there are so many interesting little sub-cases that have little bits and pieces of information that will play into this. Like in the Skermetti case last summer, which was about whether Tennessee could restrict medical care to trans kids. And the court decided that they could, but they said they could because this law was discriminating based on medical care and not on anything else. So they basically didn't even ask about whether you could discriminate against. They cut the real question off, essentially. And Justice Barrett wrote this concurring opinion where she said, you know, I think everybody's been reading this question. You know, she was like, we didn't answer this question about whether or not transgender people are a separate protected class or not. But I also think that the attempts to do so in the briefs were wrong. They didn't answer the questions properly. And I would like to see them answered this way so that I can properly address them. Because I think they answered it this way, and so they didn't even answer the questions I want to hear answers to. And so she laid out a roadmap for creating a new protected class potentially, which is interesting. She starts by saying, look, we haven't added a new protected class in 40 years. We are not likely to do it now. But this is the thing that I'm missing in this discussion. And it was about, she wanted to see questions about a history of legal discrimination, like how laws have discriminated against trans people throughout history. She said that has not been properly addressed. She's like, I think that is a key factor to answering this, and it has not been properly addressed in the briefs. So next time I see one of these cases, I want to see that argued. And I was like, oh, she's interested in hearing that, which I'm really interested to see that. So like, there's just little things like this. Yeah, I mean, Ms. Hazza, absolutely. This is their lives, but we have to. My point is that there's a possibility that Justice Barrett is considering the opening up a new roadway here, which is new territory. I would really like to see if that's a possibility. So, and you have to, as a lawyer, we have to look at things this way. This is like when doctors look at people with diseases kind of in the abstract. You sort of have to, because this is how we fix things. You have to understand them to fix them. So, so it's a new protected class would be very interesting. And again, she starts out by saying this hasn't happened in 40 years. But that's an interesting step that she may have opened up. So, and I don't know. I don't know if but I'm just really fascinated that she was willing to hear that talk. The one other thing that I found a little bit concerning is that Gorsuch's opinion. And this is just something I'm saying in advance because this is just something that stuck in my head, is he is the one who created the Title VII protection for trans people in the workplace. But he specifically says that this is based on discrimination, which he defines as treating one person worse than other people. And because he is so grammary, it worried me that specifically the sport question may to him not rise to the level of treatment, because he said so, firing somebody, definitely treating them worse. I don't know how he will respond to the question of telling someone they can't play a sport and whether that rises to the same level. I have no idea, but it's just an interesting thing to think about and watch for when we're going to see these arguments. So this is going to be tomorrow. This is a big one. So I just wanted you guys to all be prepared for this and kind of thinking about it. I will lay it all out in a morning report beforehand, hopefully well beforehand, so that because I've rewritten the script for it like 10 times, but it's just still not ready. Yeah, I'm just getting more and more interested by her because Barrett is interesting to me. Anyway, all right, guys, I am going to take a break for a little bit and then get working on tomorrow. So, do I have something for you to read in the files? Yes, did you see it? It was it was the article on. Hold on, I'll tell you. The opening line of the article is, when, if ever, may a state prosecute a federal officer for alleged criminal conduct undertaken in discharge of federal duties? And this is an article from 2003. It is in my, it's under criminal and Minneapolis, I think. This is just kind of a review of the existing case law as of 2003, but it also notes that there's not a ton of case law. No, something different? I don't know. For the case tomorrow. Bostock. Probably worth a read. Black Swan, yes. Yeah, I mean, I kind of mix them in. And I try to mix, I try to make every one of my like daily reports have something new on a legal issue that I'm teaching. So I try to, mix it in. I have no idea what's going to happen. I can tell you the past. I can't tell you the future, unfortunately. Black letter of the law is it's a term of art. It's something that we use in law school a lot to, because case law is usually really full of nuance. It's all about, well, in this situation, these 10 things happened, and we're going to rely on this perfect combination of these 10 things to make our decision. But if you cut right down to it, we're going to say that as long as these 3 things happen, we'll make the same decision. And that is what we'll call the black letter law. But it's a term of art. Yeah, it's something your law school professors say. So, this is the nuance, this is the nuance, this is the nuance, but the black letter law out of this case is that if this happens, then the court will always do this, or almost always do this. So, can the DOJ stop the state of Minnesota? The question is, and this is what we talked about today, is more probably about removal into federal court. But if it does get removal, it will get removed using maybe state laws. I don't know. Yeah, I got to take a break, guys. I'll work on predicting the future. Supreme Court case for tomorrow. It's so Little v. Hecox is one of them. Little v. Hecox. And West Virginia v. BPJ. If you Google those two things, Little v. Hecox and West Virginia v. BPJ, you should be able to find some things on them. But the problem is that they'll all be article. Nothing's defined yet. Nothing's decided yet. So the 4 corners of the law, the 4 corners ruled, which just means, within the 4 corners of this piece of paper. CompuBear, is that good? If you go to, if you look one of those up, like Little v. Hecox, and follow the SCOTUS blog link, it'll have right at the top, it'll have a link to the Supreme Court docket and all the list of stuff. So, all right, guys. Yeah. I will see you all later. Definitely see you tomorrow. Be live again tomorrow at 10 a.m. So, all right. Thanks, everybody. Takes me a little longer to stop the other ones.